Thanks. Then space wise, page number 5, cell number 28 to 30. Page number 6, cell number 31 to 36. Page 7, cell number 37 to 42. Page 8, cell number 43 to 47.
Request of Learned Council for the appellant released on Monday. Is this 8 objections? Market value for jurisdiction of the appeal is 96,987.
And with the interest is added, the date of petition, claim petition, it will cross 1 lakh crore.
Question of what is the appeal value of the appeal? Interest ain't coupled with the interest is a subsequent.
From the date of petition,
You should have said so in your appeal. You should have mentioned that in your appeal. Your appeal says 96,987, which is less than 1 lakh. How you can increase? What was the value before the tribunal?
Tribunal, they claimed the 30 lakhs. They have claimed they are for compensation of 30 lakhs.
What is granted?
Granted is 96,987. Plus interest 6% from the date of the petition.
5366 96,987. So appeal is not maintainable.
Added the interest from the date of claim petition, interest at 6% has been awarded. And if 6% is awarded as on the date of filing of the petition, it should be more than 1,04,000. This is the award.
No, I am seeing the award.
And this is 6% interest from the date of the claim petition.
What are you telling me?
Liability is a case against the appeal.
But you do what you want to do. This is going to be maintained like this. It is going to be dismissed. Yesterday, I have dismissed one matter. Week's time granted to comply. Week's time granted to comply. Same. 2 weeks time granted to comply. Notice to R2 dispensed as liabilities admitted by R1. Reliance General. Reliance here appear. The Pradeep Learned Council. The Pradeep is directed to take notice for R1 registry to show its name in the cost list. Copy to be served. So that is not possible. Something wrong here. What is ಸ್ವಲ್ಪ Yes, 5.
Five. Prakash Akeli.
Avoid trial court records. You want trial court records? All right, then you can argue. Pass over.
Number 6.
Oriental Insurance Company. Shankar Reddy sir ಇರ್ತಾರೆ.
Mr. Shankar Reddy. You take notice, sir. That counsel Sri C. Shankar Reddy. C. Your initial is C. Yes. C. Shankar Reddy is directed to take notice. Correspondent number 2. Copies to be furnished.
Right. Consent Shetty.
ಇದನ್ನು Oriental Insurance.
Same one. Same one. Copies for your copy. All three are arising out of the same accident. All these matters together. All list those MFA's numbers. All these matters together.
9. Janardhan Reddy.
The claimant was also filed an appeal 1312/21. In that case was disposed. I have filed this appeal of liability for the challenge liability matter. I have filed a recall application in the connected case. In this case, the notice was not served. Same address was furnished in the claim petition. Appeal paid with the claimants also. I have the 3 months appeal is the paid an appeal. And somebody copy to 3 months appeal now. In this case, all of the claimant.
Unclaimed liability.
Yes, sir.
Claim has to be treated as served.
ಅವರ ಪೇಮೆಂಟ್ ಅಪೀಲ್ ಇದೆ ಅಡ್ರೆಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ
No, so
ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಸಲ ಮಾಡ್ತೀನಿ ಸಿಪಾಸ್ ಸರ್
Learned counsel for the appellant is permitted to take out notice on the counsel for respondent who had appeared in MFA
1312/21
1312 of 21 disposed of.
Because of I file a recall application also in that case.
It was disposed of and an application to recall the said order has been filed by the present appellant insurance company. Sir, you can also note the postal shara of notice to R1 is returned as unclaimed and same is held to be sufficient. Show the name of respondent number 1, the cost list.
10.
Notice is held sufficient, you can tell him.
Yes, ma'am.
10 Vijay Kumar D.
Mentioned below the target class that the petitioner has raised after pronouncement of judgment class. That is not mentioned below.
That's the objection.
That is one.
The note mentioned below the first title of the appeal memo with regards to the death of first claimant before the tribunal. Immediately after the pronouncement of the judgment of the tribunal on 15/2/2021 is accepted. Immediately in the
Announcement of the
judgment is pronounced in 14/15. Immediately along. After the judgment is pronounced and prior to the filing of the appeal. Notice accepted, issue notice to respond.
11.
Objections that I am not, they have not seen on trial court seen on the copy of the judgment.
Hmm.
It's the copy that we received, my lord. On the trial court, we applied for it. Not full copy.
Something is wrong. Something is wrong. How you can, they can give you without a round seal.
They have provided us that.
How did you take it? You should have gone and taken the round seal. You don't know how to obtain certified copy and produce it in High Court. Before producing, you should have seen it and got it rectified. I'll grant you a week's time. Despite this, take another one.
And apply for this. And the receipt for the final execution, the receipt for arrest warrant.
You are owner. Are you owner?
No, my lord, I am state, tax
You are for the corporation.
corporation.
Accepting the submission of learned counsel for the appellant. At the registry of the trial court, are provided the round seal on every page of the judgment in the certified copy. Petition is overruled for the time being, directing the appellant to produce another copy of the judgment, certified copy of the judgment within 3 weeks. On time?
The delay.
The delay.
Please, my lord.
Where is your IE?
Yes, sir.
Need consideration, issue or learned counsel for the appellant, issue notice. Respondent. Separate. The consideration of IE number 1. IE number 2 is taken up by imposing certain conditions that shall be free of operation and execution of the judgment and award. Dated 24/3/23 in NDC 3461 of 19. Passed by the 14th additional. Versus Judge and MACT Bangalore. CCH subject to the condition that the appellant deposits 50% of the award amount before the jurisdictional tribunal in 4 weeks from today.
See that side along MPA number 4037 of 23, madam. This is an appeal filed by the respondent themselves.
In the same case,
Same case,
this time MFA 4037
4037 of 2023.
of 2020.
J-30.
Yeah, the question is that madam, the petition, the appellant, the executive appellant in the last. If the pendency of the petition, madam, the answer, I will render it. The guardian was distant.
The three officers.
There are 3 other objections. Apply that, then we'll overrule this. Apply ಮಾಡಿದ್ದೀರಾ? Fatima? It's time granted to comply.
The subject will be over.
Which is this objection?
The plan to be correctly stated.
No, which is this objection with regard to minority? What is the age of that claimant before the tribunal?
18.
18.
At the time of disposal of the claim petition, madam, 19 years.
ಇವಾಗ by the time of filing the appeal is major.
Major.
ಆಗಿದ್ದಾರಾ?
What appeal is?
Objections raised by the registry at serial number 1 and 2 is overruled. View of the appellant who was the claimant before the tribunal having attained majority.
Pradeep, please.
Regarding conflict of mission, data for disposal management, judgment may be judgment and management.
That is the only objection.
Only objection, award is mentioned when it's 16/5 of 2023. Page number 46.
Page number
43. So they have one signature and 16/5.
So what is the correct date?
Correct date number is 9th May.
The learned counsel for the appellant submits at the correct date of disposal of the petition is on 9th May 2023, which is stated in the first page of the judgment, imputed judgment. However, in the decree, in the award will matra change again. The signature, below the signature, it is mentioned as 16/5. The error is committed by the tribunal, hence there's no fault by the appellant. Petitions raised by the registry is overruled. Or learned counsel or the appellant should notice to respondent. Respondents, in consideration of IA number 1 of 23, IA number 2 is taken up with by imposing certain conditions. There shall be stay of operation, execution of the judgment and award dated 9th May 23. In NVC 886 of 22, passed by the 14th Additional Civil Judge, MACT, Bangalore, CH-10, subject to the condition that the deposits 50% of the award amount within 4 weeks for this court. Notice to respondent number 2 is dismissed. Risk of appellant.
Your last statement of your last statement regarding integrity of the field. And such that current no such judgment must notice.
Is that judgment? It is not reported.
It is.
Will not be reported. The value of the appeal is 30,000 according to you,
Please,
not maintained.
but it may be happened.
How I can differ from my own judgment?
I will assist you that. Not that I had done. It is binding under that situation. The matter has to refer to the division. That's the reason. I
Which-
look into a make this. If there is another judgment which is already reported, which was not.
No, that is a writ petition, that is not a MFA.
The observation is the appeal.
Observation in the writ court is you can go and file an appeal. That doesn't mean that the appellate court has decided the matter. Sending the matter from a writ court to a CRP or a MFA is stating that writ is not maintainable, you go to the other forum, but the other forum has not decided.
That is. That's the reason.
You bring,
I look into and I make this.
and whatever you are arguing, that is not forthcoming in the act. That is your submission. Huh?
Implicate, that is the.
The implication you cannot draw, the legislate, white building implication mark, now madaku barala.
That I.
Even the court cannot.
I will give it it's only an attempt.
Of course. In fact, yesterday there was one more matter. I told him to speak to you, but he came without speaking to you. And I dismissed that yesterday on the same ground.
In my case, the claim is, otherwise I have forwarded this, the amendment application also to the company for putting this in this, because the claim amount is 2 lakh under my, therefore, under that ground also my appeal is made, but I have to plead that.
Correct.
Therefore, I have to amend the, that also consequently I am forwarded those.
Draft ಮಾಡಿದ್ದೆ ನೀವೇ ಅಲ್ವಾ?
ಅಲ್ಲ ಬಟ್ ಆವಾಗ ಇಲ್ಲಿ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಇಟ್ಕೊಂಡು ನಾನು ಅವ್ರ ಡ್ರಾಫ್ಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಈಗ ಸಿಚುಯೇಷನ್ ಇಸ್ ಎಂಟರ್ಲಿ ಡಿಫರೆಂಟ್. therefore the claim amount has to need to be mentioned in the thing. Amendment ಗೆ ಕಳಿಸೋದು ಈ ಕಂಪನಿಗೆ ಸೈನ್ ಮಾಡ್ಕೊಂಡು ಬಂದಲ್ಲ.
Briefs and granted at request of learned counsel for the appellant. Without the paper book,
Permission, I don't know about the concurrent findings there.
concurrent finding, suit for possession. You are plaintiff.
They had created,
You are plaintiff,
are the plaintiff.
you are defendant.
Defendant.
So you are successful in both the
Was
courts.
it
Possession ordered,
or possession?
not
They
given.
create adverse possession. Adverse possession in what manner, how is it not being created? My ownership and petition.
So whether trial court records are required, without that, if I can argue. 2016 matter, stay was granted. Admitted.
On 18/7/2016. It is state.
All right, I'll hear you next week. When do you want? Take a date and argue on that day. Huh?
First of March. It is Thursday, not 29th of first.
Yes, you are okay.
Friday, it's Friday. Friday, I have mediation afternoon and morning.
Either 29th or 1st,
29th of first.
1st March. At the request of both the learned counsel, the matter would be taken up for hearing on 1st March. Paper books are dispensed at request of learned counsel for the appellant.
Brief Hedges.
Mr. Counsel, have you seen the question of law framed by the court? Have you seen the question of law framed by the court? Don't come and argue out of the context. You can see if you want and stick to the arguments of the substantial question of law.
Brief Pradeep Hedges.
Yeah, the respondent, something. The respondent has tried to work out only the respondent.
Five to 10 years, not fine. We take notice.
It is pending. By time not coinciding this, and there is variance. We have the variance in trial court. There are the different. Try to.
He is the contesting the.
Yarrow,
Respondent number 1.
One.
They are the plaintiff. He is the respondent.
you are a defendant.
And the defendant before the claim.
Which defendant?
Defendant number 7 to 14, right? Who are the appellant before this?
7 to?
7 to 14.
So the defendant number 5, this our respondent number 5 to 10 or 1 to 7, 1 to 6.
They are the
Co-defendant.
family members of the,
They are co-defendants with you.
they are not co-defendants, but they are the family members of the
Co-defendant, no, not co-defendant.
co-defendant party, they are co-defendant.
They're not co-defendant.
They are the party members, they are the members of their family.
Really, they are defendants along with you in the trial court. They are the plaintiffs.
They are
All of you are family members.
depend, the respond number 5 to 10 are the family members of the respond number 1 to 4 here. They are the children and
Family members ಅಲ್ವಾ
family members.
ನಾನು ಹೇಳಿದಕ್ಕೆ ಅದು ಉಲ್ಟಾ ಹೇಳ್ತಿರೋದು
Other family members.
ನಿಮಗಲ್ರಿ ಅವ್ರು ಹೂ ಆರ್ ಯು ಆರ್ ಡಿಫೆಂಡೆಂಟ್ ಪರ್ಚೇಸರ್ council to take out notice to respondents 5 to 10. What about what is the matter now? This whether it's admitted or not admitted.
It is not admitted in last application. They come that let the respondent must appear.
Yes.
Against the invitation for the son. They are not to write this book within the 3 years after the measure of they are against the measure. For admission.
It is listed for admission. It is for okay notice. Take out, you want these people to be on record now. Any relief is sought against them.
No, you.
Take steps.
Kindly dispense and put for admission. If they have paid the equipment, the commissioner is also appointed with us. Not given the merits of the admission.
Respondents number 5 to 10, who are the family members of 1 to 4. Any share is given to them.
The Mohammedan partitions, they make that. What is the reason? The place expired in this side.
Your ex parte before the trial court.
Right, totally, they are not contested, but they are filed written statement, but
Good
they are
enough.
not contested. Being admission. Five, internal page number 58, para number 4 of the statement pathway defined, very small observation is there, the appearance of these respondent number 5 to 10. During the pendency of the penalty court, included item number 4 to 5, additional content in that. Item number 2 to 5 are relevant for the upon service of command, different number 2, 5 did not object before as such. 3, 4 and 7 14 appeared before the court. Sufficient to the custom and use the something have not
Where are you reading?
in internal page number 59, that is the trial court judgment passed in various number 87. Para number 3. 6.
Para number.
3. Bottom.
Yes.
On service of command of different 2, 5 and 6. Is not appeared by before. As such, there was placed ex parte. Different number 3, 4 and 7 to 14 have appeared before the court. Through counsel, someone to the first petition has been served before the date on 28/3/2006, finding from the legal rights of first petition available in record. Different number 3 and 4 have not time. Different number 7, 14 have submitted joint content.
So now who are these respondents number 5 to 10?
They are different number 2, 5, 6.
3 and 4. 2, 3, 4, 5 and 6. 3 and 4 have come on record.
Placed expert before.
No. 3 and 4 have filed, appeared before the court.
3 and 4 and 7 to 14 have appeared, but 3 and 4 have not been written.
They have appeared, they are not ex parte.
They are not there. They are uncontested.
So now in the FTP proceedings, they are party.
They are sir.
You take notice to the council. All right, now you are the plaintiff.
Yes.
What is the question of law involved?
In case is that their case before they try for that, they are not party to this AD. And during the
All right, you argue the matter today. You want to argue today? It's on Monday at request of the appellant.
Is number 17. Is that okay?
the application for the of this going in the project. Feeling on liability that, but yeah, we can 28 merit, it may be disposed of. It may be considered. For some of them,
Dispose of the main matter.
it's very.
We can argue today.
28. Okay.
Request of learned counsel for the appellant released on 28th. Which the matter would be heard on the main.
It's when I go next.
But you have decided to argue the matter.
I am ready to address the request.
Because
Because in this case, I am challenging the liability. Only though that the driving license of the accused is not having a driving license. They have given some other driving license which we produced before the court.
he's not the accused, he's a claimant.
If the driver is not having a driving license, I am not liable to pay compensation. One of the recent judgment of Nizam court.
Yavudu.
So, 6 months of 2019.
Division bench judgment.
Please.
Justice Mutkal's. Release the amount, then you can argue. But I have referred, in your case only. No, it will amount to pay and recover, that's all.
Yes. That is, we are.
See, that judgment is referred to Pappu's case. Huh?
It's referred,
Ah.
but paid recovery was not given.
It was not given in the division bench.
Supreme Court judgment paid recovery. But in our, that's what I read to make decision maker held, but Supreme Court paid recovery are.
So which will survive for me to decide?
It's my duty to practice the last
Correct.
knowledge.
No, my knowledge you have brought. Your knowledge, you also have to fairly say, the Supreme Court has said like this, division bench has said like this. So which will take a better opinion? Precedence. Precedence is also Supreme Court. On records, I will get the records, I will release the amount. How much is deposited? 50%. Where have you deposited? MACT. What order sheet is
But it is deposited on 11/8/2002.
11/8?
I need to produce the acknowledgement, but it
No,
is.
that's okay.
Check there.
No, we believe you, sir. You have deposited Alva.
Please.
Believe the version of the learned counsel. This court will believe the version of learned counsel. The counsel for the appellant and respondent are present. The counsel for the respondent has filed an application IA number 1 of 2024. Seeking permission to withdraw the amount deposited by the appellant insurance company to an extent of 50% of the award amount. The counsel for the appellant confirms the deposit of the said amount as ordered by this court. Stop. The appellant has questioned the liability and quantum in this appeal. It will be only liability. Quantum only question the liability on the ground that the driver of the offending vehicle did not possess a valid and effective driving license. That as it may, the respondent claimants have filed an application to withdraw the amount already deposited by the appellant insurance company. Being satisfied with the reasons assigned and cost shown, considering the need of the respondent for utilization of the amount as of now, this court deems it appropriate to allow the application. Accordingly, IA number 1 of 24 is allowed. Respondents number 1, number 1 to 3 and 5 are permitted to withdraw the amount deposited by the appellant before the jurisdictional tribunal in accordance to the proportionate share.
Yes.
In accordance to the share allotted by the tribunal, the amount shall be released upon proper identification. Registry to secure trial court records.
When I secure the award, that thing submitted now.
The counsel for the appellant has filed 2 applications to recall the order dated 1/2/2023 to condone the delay in filing the application to recall. It is order of dismissal. Stop. And there is the affidavit annexed to the application being satisfied with the reasons assigned and cost shown. Applications are allowed. Delay of 80 days in filing the said application is controlled. Order dated 1/2/2023 is hereby recalled. To the appellant, making it taking cost of rupees 223. Order. That is almost. Payment of cost of rupees 1,000 to the advocates, clerks, benevolent. Bengaluru Professionals Benevolent Fund. Bengaluru Professionals Benevolent Fund. 2 weeks, and he shall comply with the objections within 2 weeks.
Vijay Kumar.
Yes, I have prepared a 6/7/2022. I feel that the tax council also. It is not in station. Therefore, yes, to both along with the other. And I wish, answer. And I have answered.
Wednesday, 28.
Please.
Or
Both along with.
list MFA number sounds pretty up.
6724 of 22.
The case of death,
Yes, case of death.
In this case, I think for the restaurant number 4, there is a not moving event accordingly we have satisfied the KSR is prepared victim. And it must be Sigma is not in space in the time representing and the also. Between the African
no, what is he challenging?
Challenging on the ingredients and quantum. Challenging on the materials and quantum. 2 vehicles involved in that. Materials is decided in that 50%.
50% on the corporation.
On the correspondent, 4th respondent as well as the corporation. 4th respondent,
The claimant is a third party.
yes,
How it is going to affect the claimant?
but the Vijay Kumar said when he is not in station, therefore what is to get an adjustment all along with their appeal, affect every disposal. We are not prepared appeal, we are satisfied here.
Correct. So your amount now, you're not preferred an appeal.
No, means
So you have paid 50% of the amount.
that they are already
Satisfied.
You satisfied and withdrawn also.
because
So the amount of what that you want to withdraw.
that they are seeing.
Only 50% of the our amount is guaranteed.
So even if that 50% is going to be saddled on you, Mr. Shivanagowda, what is already filed, paid by him, they can withdraw.
That they have already withdrawn and.
ನಿಮ್ದಲ್ರಿ
Usually. So
ವಿಜಯ್ ಕುಮಾರ್ ಅವರು he must have obtained stay ಅಲ್ವಾ?
proper person to say that because I am appealing for the respondent of 4 also.
All right.
It is not.
So we'll dispose of the matter on Wednesday
Please.
at the request of learned counsel for appellant. This matter on 28th.
In this case also there is another connected matter. 8597 of 23 in Karnataka.
Serial number 20 ಅಲ್ಲಿ one more matter ಇದೆಯಾ?
6724 of 20.
ಅದು ಬರ್ಕೊಂಡಮ್ಮ list MFA so and so along with this appeal. Yes, in 21.
21 they were prepared 8597 of 23 in Karnataka. And let me say.
List MFA 85.
8597 of 23.
8597 of 23 along with this appeal. Call this matter on 28.
It's much.
This will be carried.
Notice,
Notice will be dispensed.
notice to R2 dispensed with risk of appellant, issue notice to R1. Notice to R2 is dispensed at the risk of appellant, issue notice to R1. Issue notice to R1, notice to R2 is dispensed at the risk of appellant. For your claimant, first time, issue notice.
7.
I wrote the certificate copy produced was in connected matter.
A number 1 of 2024 is allowed. Certificate copy of the judgment is dispensed in view of the same having been produced in MFA number
1091 of 24.
1091 of 24. 2. Notice to respondents. What's on IA2? There shall be stay of operation and execution of the judgment and award. Dated 1/12/23 in MVC 109 of 22. Asked by Court of Senior Civil Judge MACT and JMFC at Tiptur. Subject to the condition that the appellant deposits 50% of the award amount before this court within 4 weeks from today.
Number 28. Okay. Correspondent.
Case of individual. The other.
Here from the,
Yes, sir, you're ready?
yes, I am ready, my lord.
Yesterday's matter.
Yes, ma'am.
Yesterday's meeting.
The case of individual, the accident occurred on 14/12/2017.
You're able to hear Mr. Mahesh? ಅವ್ರು ಮಾತಾಡೋದು ಕೇಳಿಸುತ್ತಾ?
ಅಲ್ಲ ಅವ್ರು ಅಡ್ವೊಕೇಟ್ ಮಾತಾಡೋದು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಸ್ವಲ್ಪ ವಾಲ್ಯೂಮ್ ಕೊಡಿ. Just take the mic closer please. ಟ್ಯಾಪ್ ಮಾಡಿ ಇದು ಮಾಡಿ. All right, we'll see how much you can hear.
Okay. 14/12/2019.
ಹಾ,
The authority stated about 17 years.
increase ಮಾಡಿ ಸ್ವಲ್ಪ ವಾಲ್ಯೂಮ್.
The standard alternative. Move the left elbow joint, ablation of the left thigh and right ankle position. Right ankle raise was fracture. Just take the independent treatment for a period of 5 days. But ablation ankle is very good.
The sound which was already coming earlier is now not coming.
Otherwise, inpatient treatment has taken money.
Hmm.
But he has spent rupees 45,275 rupees.
Hmm.
Whereas the doctor was examined at PW2.
Hmm.
He said that the applied that disability of 36.36% to right lower limb and 12% whole body disability.
12%?
0.12.
Which
12 plus 0.12%. That was judgment para number 15, 16. B, disability. Number 12 of the judgment, 13 of the judgment.
Yes.
He is recently examined the petition assessed the disability on mobility and stability component. He assessed the disability to an extent of 36.36% to the right lower limb and whole body disability is 12.10%. The trial court considered 10% only.
All right.
But if the applicant is working as a milk distribution at BK Enterprises, Kuala Bangalore, he is earning rupees 15,000 per month.
Hmm.
The trial court considered 8,000 rupees.
8,000.
8,000 rupees. As of the later payment, the trial court awarded 8,000 into 24,000.
Hmm.
And communities mother the trial court awarded 20%, 20,000 rupees. Actually, in 2007, after the local level started, 11,000 rupees may be considered.
Hmm.
And awarded suitable compensation all the years.
Hmm. Can I?
On that.
Yes, Mr. Mahesh.
But my appeal, my lord, is on question of, my lord, the negligence and quantum.
Put in. Yes. Yes, please.
It's a case of injury, my lord. A minor aged about 17 years.
Hmm.
Trying to be, my lord, milk distributor and earning rupees 15,000 per month.
Hmm.
Date of accident, my lord, is 14/12/2017 at 9:30 PM. On Kuvempu Nagar Main Road, Bangalore.
Hmm.
It is stated, my lord, that the minor was traveling as a pillion rider on motorcycle bearing registration number KA04JL 1050. The rider of which, my lord, is the father of the injured.
Right.
But in this respect, you often kindly see, minor, my lord, has not entered the witness box, the mother has been examined.
Hmm.
The petition was presented on 24/10/2018.
Hmm.
And he was major at that point of time. Even at the time of during trial also, my lord, he attained majority and he had not entered the witness box.
Hmm.
Only mother. The appellant, my lord, Liberty Insurance Company, the first respondent before the governor, contended, my lord, denying the averments of the claim petition while contending that the vehicle is not involved, not due to the negligence of the rider of the motorcycle.
Hmm.
The second respondent, my lord, the father of the injured and owner insured, after service of notice, my lord, though appeared, no statement was filed.
Hmm.
Yes. But in this respect, my lord, I invite your lordship attention to the grounds, my lord, which I have raised. In page 4, my lord, of my appeal. Ground number 3 and 4.
Yes, sir.
But here you have to kindly see. The mother was examined as PW1, admittedly not an eyewitness.
Yes.
Complainant, my lord, is said to be one Gopalaya. And as per the police record, he is also not eyewitness.
Hmm.
And the statement was said to have been given by the mother to the Jalahalli police station. That does not bear, my lord, any date or time when it was made.
Hmm.
In respect of that, my lord, I invite your lordship attention to the evidence of PW1, the mother.
Obviously, she would have said she has not seen the incident.
Pardon?
Obviously, she would have said she has not seen the incident.
Yeah. Then, my lord, the cross-examination may kindly be looked into, my lord, insofar as the, my lord, the avocation and income claimed by the, my lord, the claimant.
What you want to read in the evidence of PW1?
PW1, my lord, at page 5, cross-examination.
Yes, yes.
ಅಪಘಾತವನ್ನು ನಾನು ನೋಡಿರುವುದಿಲ್ಲ. ನಾನು ಇಂದು ನ್ಯಾಯಾಲಯಕ್ಕೆ ನನ್ನ ಯಜಮಾನರಾದ ಆರೋಗ್ಯ ಸ್ವಾಮಿ ಜೊತೆಯಲ್ಲಿ ಬಂದಿದ್ದೇನೆ. ದಟ್ ದಿ ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ಇನ್ಶೂರ್ಡ್. ಎರಡನೇ ಎರದಾರು ನನ್ನ ಯಜಮಾನರು ಎಂದರೆ ಸರಿ. ನನ್ನ ಮಗ ಅಗಸ್ಟಿನ್ ಮೆರಿಯೋ ಈಗ ಡಿಪ್ಲೊಮಾ ಓದುತ್ತಿದ್ದಾನೆ. ಅರ್ಜಿದಾರರಿಗೆ ಮೋಟರ್ ಸೈಕಲ್ ಚಲಾಯಿಸಲು ಚಾಲನಾ ಪರವಾನಗಿ ಇರುವುದಿಲ್ಲ. ದಿನಾಂಕ 14/12/2017 ಆದ ಅಪಘಾತದಲ್ಲಿ ಒಬ್ಬರಿಗೆ ಗಾಯವಾಗಿದ್ದು ಇನ್ನೊಬ್ಬರು ತೀರಿಕೊಂಡಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ದಿನಾಂಕ 14/12/17 ನನ್ನ ಮಗ ಮೋಟರ್ ಸೈಕಲ್ ಚಲಾಯಿಸುತ್ತಿದ್ದ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಮಗ ಅಪ್ರಾಪ್ತ ವಯಸ್ಕನಾಗಿದ್ದು ಚಾಲನೆ ಪರವಾನಗಿ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಎರಡನೇ ಎದುರುದಾರರು ಮೋಟರ್ ಸೈಕಲ್ ಅನ್ನು ಚಲಾಯಿಸುತ್ತಿದ್ದರು ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಪಘಾತದ ಬಗ್ಗೆ ದೂರನ್ನು ಗೋಪಾಲ್ ಎನ್ನುವರು ನೀಡಿರುತ್ತಾರೆ. ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳ ಬಗ್ಗೆ ನನಗೆ ಸಂಪೂರ್ಣ ಮಾಹಿತಿ ಇದೆ. ದೂರಿನಲ್ಲಿ ಮೋಟರ್ ಸೈಕಲ್ ಸವಾರ ಹಾಗೂ ಮೃತಪಟ್ಟ ವ್ಯಕ್ತಿ ಬಿಟ್ಟರೆ ಮೂರನೇ ವ್ಯಕ್ತಿಯ ಹೆಸರು ನಮೂದು ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ಪೊಲೀಸರಿಗೆ ನಾನು ದೂರು ನೀಡಿರುವುದಿಲ್ಲ. ನಮ್ಮ ಯಜಮಾನರು ಸ್ವಂತ ವ್ಯವಹಾರ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ. ನಮ್ಮ ಯಜಮಾನರು ಸೆಕ್ಯೂರಿಟಿ ಡೆಪ್ಯೂಟಿ ಮಾಡುವ ಕಚೇರಿ ಇಟ್ಟುಕೊಂಡಿದ್ದಾರೆ. ಅದರ ಒಂದು ಶಾಖೆ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಇದ್ದು ಇನ್ನೊಂದು ಜಯನಗರದಲ್ಲಿ ಇದೆ. ಅಪಘಾತವನ್ನು ನೋಡಿದವರನ್ನು ಸಾಕ್ಷಿ ಮಾಡಿಸಲು ನನಗೆ ಆಗುವುದಿಲ್ಲ. ನಾನು ಕ್ರಿಮಿನಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಾಕ್ಷಿ ನುಡಿಯಲು ಹೋಗಿರುವುದಿಲ್ಲ. ಅಪಘಾತ ಆದ ಬಗ್ಗೆ ನನಗೆ ಸುಮಾರು 9:45ಕ್ಕೆ ಗೊತ್ತಾಯಿತು. ನಾನು ಅಪಘಾತ ಆದ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿರುವುದಿಲ್ಲ. ಅಪಘಾತ ಸಂಬಂಧ ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ನಾನು ಮನೆಯಲ್ಲಿ ಒಂದು ಮೋಟರ್ ಇರುತ್ತದೆ. ಮೋಟರ್ ಅನ್ನು ಪೊಲೀಸರು ಅಮಾನತುಪಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ನನ್ನ ಮಗನನ್ನು ಸಾರ್ವಜನಿಕರು ಮತ್ತು ನಮ್ಮ ಯಜಮಾನರು ರಾಜಲಕ್ಷ್ಮಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. ಅಪಘಾತ ಆದ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮಗ ಪ್ರಥಮ PUC ಓದುತ್ತಿದ್ದರು ಎಂದರೆ ಸರಿ. ನನ್ನ ಮಗ ರಾಜಲಕ್ಷ್ಮಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ 6 ದಿನ ಒಳರೋಗಿಯಾಗಿದ್ದು ಆಸ್ಪತ್ರೆ ಬಿಲ್ಲನ್ನು ಸೋಣಿಸು. ಪ್ಯಾರಾ ನಂಬರ್ 4 ಮತ್ತು 5ರಲ್ಲಿ ಇಲ್ಲಿರುವ ವಿಚಾರ ಸುಳ್ಳು ಎಂದರೆ ಸರಿಯಲ್ಲ. This is the evidence of the mother. What I would like to stress before worship is why the injured who had attained majority was reluctant to enter the witness box. The circumstances shows that at the time of the accident, he was the rider. Because he didn't have a license, the father was substituted as a rider. That is one reason, which can be inferred. Then, the sketch may kindly be looked into,
Exhibit.
Exhibit
6.
Exhibit P6, There, they show that a pedestrian was crossing the road. And thereby, the accident occurred. If that is so, my respectful submission, the alleged accident was neither due to rash or negligent act of the father who was said to be the rider at the point of time, and the injured was a pillion rider. It is due to the negligence of the pedestrian who all of a sudden darted across the road in between the two parked vehicles.
Yes.
Yes. Then, the nature of injury, will probably that the injured himself was not riding the vehicle, otherwise he would not have sustained that type of injury. And the father was not treated, he was not injured. Therefore, you have to kindly see preponderance and probability would indicate that the injured himself was riding the motorcycle and sustained injuries. The nature of injuries would probabilize that he himself was riding the motorcycle, and also the IMA report, which has been marked as exhibit P7, probabilize that.
Yes.
Yes. Then you will kindly see That is regarding, my lord, the question of negligence. And regarding, my lord, the contention that he was, my lord, milk distributor is not proved. In that respect, my lord, I invite your lordship attention to the evidence of mother PW1 at examination chief para 5. I submit that at the time of accident, my son was working as a milk distributor at VK Enterprises, Kuvempu Nagar, and was earning rupees 15,000 per month. Here you would kindly see, in respect of this alleged, my lord, the avocation, no document has been, my lord, produced. The exhibit P12, my lord, the IP record shows that he is a student. And apart from that, my lord, there is no documentary evidence or oral evidence in respect of his alleged avocation and income. Then, my lord, in this respect, my lord, I invite your lordship attention to evidence of PW2.
What do you want? You mentioned in exhibit P12?
P12, my lord, student. He
Alright.
mentioned a student. Suppose if you were gainfully employed, my lord, that would have been spelled out.
All right.
Then, my lord, I invite your lordship attention to evidence of PW2 doctor. Cross-examination, my lord. Typed page 4 of PW2. ಅರ್ಜಿದಾರರ ನ್ಯೂನತೆಯನ್ನು ಅಳೆಯುವ ಮೊದಲು ಐಪಿ ರೆಕಾರ್ಡ್ ಎಕ್ಸ್ರೇ ಹಾಗೂ ಕ್ಲಿನಿಕ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನೋಡಿರ್ತೇನೆ. PW2, my lord, typed page 4 of the equation, cross-examination, my lord.
Yes, please.
ಪಾಟಿಸವಾಲ್ 1ನೇ ಎದುರುದಾರರ ಪರ ಕೆಪಿ ವಕೀಲರಿಂದ ಅರ್ಜಿದಾರರ ನ್ಯೂನತೆಯನ್ನು ಅಳೆಯುವ ಮೊದಲು ಐಪಿ ಕಾರ್ಡ್ ಎಕ್ಸ್ರೇ ಹಾಗೂ ಕ್ಲಿನಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನೋಡುತ್ತೇವೆ. ಅರ್ಜಿದಾರ ಬಿಡುಗಡೆ ಪತ್ರ ಹಾಗೂ ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರ ನೋಡಿರುತ್ತೇನೆ. ಅವುಗಳನ್ನು ರಾಜೇಶ್ವರಿ ಆಸ್ಪತ್ರೆಯವರು ನೀಡಿರುತ್ತಾರೆ. ಎಫ್ಸಿ ಸ್ಪೇಷಲ್ ಫ್ಯಾಕ್ಟರ್ ಬಗ್ಗೆ ಬಿಡುಗಡೆ ಪತ್ರ ಹಾಗೂ ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ನಮೂದು ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಎಸ್ಪಿ ಫೇಷಲ್ ಫ್ಯಾಕ್ಟರ್ ಹಾಗೂ ಎರಡೂ ಒಂದೇ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಅರ್ಜಿದಾರರ ಕ್ಷಕಿರಣವನ್ನು ತೆಗೆಸಿರುತ್ತೇವೆ. ಕ್ಷಕಿರಣದ ವರದಿ ಹಾಗೂ ರೇಡಿಯೋಲಾಜಿಕಲ್ ರಿಪೋರ್ಟ್ ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇದೆಯಾ ಎಂದರೆ ಸಾಕ್ಷಿಯು ರೆಕಾರ್ಡ್ ರೂಮಿನಲ್ಲಿ ಸಿಕ್ಕಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಅರ್ಜಿದಾರರಿಗೆ ಎಸ್ಪೆಷಲ್ ಫ್ಯಾಕ್ಟರ್ ಆಗದೆ ಇರುವುದರಿಂದ ವರದಿಯನ್ನು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅರ್ಜಿದಾರರಿಗೆ ಯಾವುದೇ ಶಸ್ತ್ರಚಿಕಿತ್ಸೆ ಆಗಿಲ್ಲ. ಅರ್ಜಿದಾರರ ಹಿಪ್ಪು ಹಾಗೂ ನೀ ಮೂವ್ಮೆಂಟ್ ನಾರ್ಮಲ್ ಆಗಿದೆ ಎಂದರೆ ಸರಿ. ಅರ್ಜಿದಾರರ ವೃತ್ತಿಯ ಬಗ್ಗೆ ನನಗೆ ಮಾಹಿತಿ ಇರುವುದಿಲ್ಲ. ಅರ್ಜಿದಾರರು ರಾಜಲಕ್ಷ್ಮಿ ಆಸ್ಪತ್ರೆಯಿಂದ ಮುಂದುವರೆದ ಚಿಕಿತ್ಸೆಗೆ ಪಡೆದುಕೊಂಡು ಆ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರು ಬಳಿ ಹೊರರೋಗಿ ಚೀಟಿ ಇದ್ದಿತ್ತು. ಅರ್ಜಿದಾರರು ಯಾವುದೇ ಮುಂದುವರೆದ ಚಿಕಿತ್ಸೆ ಪಡೆದುಕೊಂಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಗೆಜೆಟ್ ನ್ಯೂನತೆಯನ್ನು ಅಳೆಯಲು ಪ್ರೊಫಾರ್ಮಾ ಇದೆ ಎಂದರೆ ಸರಿ. ನಾನು ಸದರಿ ಪ್ರೊಫಾರ್ಮಾ ಅಳವಡಿಕೆ ಮಾಡಿಕೊಂಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಪ್ರೊಫಾರ್ಮಾ ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇಲ್ಲ. ನಾನು ಅರ್ಜಿದಾರರನ್ನು ಯಾವಾಗ ಪರೀಕ್ಷೆ ಮಾಡಿದ್ದೇನೆ ಎಂದು ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಹೇಳಿದ್ದ ಎಂದರೆ ಸಾಕ್ಷಿಯು 27/9/2018 ಪರೀಕ್ಷೆ ಮಾಡಿದ್ದು ಈ ಬಗ್ಗೆ ಕ್ಷಕಿರಣ ಕಂಡು ಬರುತ್ತದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಿಶಾನೆ P13 ವರದಿಯಲ್ಲಿ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ಈಗ ಅರ್ಜಿದಾರರ ಪರಿಸ್ಥಿತಿ ಬಗ್ಗೆ ನನಗೆ ಹೇಳಲಾಗುವುದಿಲ್ಲ. ಬಿಡುಗಡೆ ಹೊಂದುವಾಗ ನೀಡಿದ್ದ ಸಲಹೆಯನ್ನು ಅರ್ಜಿದಾರರು ಪಾಲಿಸಿದ್ದಾರೆಯೋ ಇಲ್ಲವೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಅರ್ಜಿದಾರರಿಗೆ ಮೂಳೆ ಮೃತ ಆಗದೇ ಇರುವುದರಿಂದ ಲಾಸ್ ಆಫ್ ಮೋಷನ್ ಅಂಡ್ ಲಾಸ್ ಆಫ್ ಮಸಲ್ಸ್ ಇಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅರ್ಜಿದಾರರ ಹಿಪ್ಪು ಮತ್ತು ನೀ ನಾರ್ಮಲ್ ಇರುವುದರಿಂದ ಅರ್ಜಿದಾರರು ನಡೆದಾಡಲು ಯಾವುದೇ ತೊಂದರೆ ಇಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಯಾವುದೇ ಗೆಜೆಟ್ ಫಾರ್ಮವನ್ನು ಅಳವಡಿಸಿ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಮ್ಮ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಅಪಘಾತದ ಬಗ್ಗೆ MLC ಮಾಡುತ್ತಾರೆ. ಈ ಕೇಸಿನಲ್ಲಿ MLC ಮಾಡಿದ್ದಾರೋ ಏನೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಅರ್ಜಿದಾರರಿಗೆ ಯಾವುದೇ ರೀತಿಯ ಮೃತ ಇಲ್ಲದಿದ್ದರೂ ಕೂಡ 12ರಷ್ಟು ಹೆಚ್ಚಿನ ನ್ಯೂನತೆ ತೋರಿಸಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. This is the my lord, then RW1 my lord is the evidence of Dr. Praveen examined my lord on behalf of the
Church company.
Dr. S. Praveen. Examination in chief by counsel for respond number 1. Since 5 years, I am working as CMO at Rajalakshmi Hospital. I have received a witness summons from this court for production of the document and speak about same. Thus, today I am present before the court and produce the following document. Exhibit R1, copy of the MLC police intimation. History of the case is not mentioned in detail in Exhibit R1. I have not produced the X-ray and radiological report of the petitioner. This is the evidence of the doctors. Lord, my respectful submission, my lord, if for any reason it is held that it is due to the negligence of the rider of the motorcycle on which he was said to be a pillion rider, then my lord is entitled only for the injury, pain and suffering, medical expenses, loss of amenities of life, nourishing food, not for future loss of earning capacity or loss of income during the period as he was a student. His income is not proved and he was shy to enter the witness box because the movements would be observed by the member of the tribunal. However, my lord, the tribunal has taken 10%, my lord, disability, which is also, my lord, is not proper because any disability, my lord, will not last for the multiplier used by the court, depending upon the, my lord, age of the claimant, 18 multiplier. Therefore, my lord, on these grounds, my respectful submission, my lord, the appeal of the, my lord, company deserves to be allowed and to be exonerated.
Policy is in force.
Insurance is not denied, my lord. Insurance is not denied.
Why you
The,
should be exonerated?
pardon?
Why you should be exonerated?
Lord, it is not due to the negligence of the, my lord, the rider of the motorcycle. Even, my lord, the father was said to be the, my lord, because a pedestrian crossed all of a sudden. It is not due to his either rash or negligent act. Under
What,
the
why you did not examine RW1, the respondent number 1?
RW1, my lord, is the, my lord, the doctor. He says,
No, no, not a doctor, according to you. Why you did not examine the father who's respondent number 1?
he has not been examined, my lord. He has also not, because you must kindly see, father and son relationship.
Right.
Son was probably, my lord, was riding the motorcycle, had no license. The injury is said to have been caused, my lord, probabilizes that he himself was riding the motorcycle and there was a, my lord, sudden crossing of a pedestrian.
Correct. That is your theory. That is your theory of the probability of the case. Why you did not summon this respondent number 2, Aropya Swami, to lead evidence on it?
My lord, he is
You-
colluding, my lord, you must kindly see, he is colluding.
All right, he's
Yes,
all
my
right.
lord, father, the second respondent, though he entered appearance, my lord, no statement was filed.
All right, if he doesn't come by himself or he is
Yeah.
not examined
My
by
lord,
the
adverse inference, my lord, adverse inference has to be drawn. And I invite your lordship attention to, my lord, section 134C of the, my lord, Motor Vehicles Act.
Yes.
And section 158(6) of the, my lord, Motor Vehicles Act, where the insured, my lord, is under statutory obligation to inform the insurance company. That is not been done. And even the, my lord, the police who have investigated are under the, my lord, statutory obligation that they have to, my lord, supply the, my lord, investigation reports to the insured.
Yes.
That is not done. So everything, my lord, is cooked up. Even said to be, my lord, the complainant had not been examined. He said to be, my lord, not an eyewitness also. PW1 is not an eyewitness. Father is interested in getting, my lord, some compensation to his injured son somehow. And he has not come forward. Even if he summoned, my lord, he would not. Well, attending circumstances.
With you that it could be that whatever probability you are saying could be the scenario which has happened and the father is colluding with the claimant.
My respectful submission, my lord, when the claimant does not lead any clinching evidence, then
Yes.
the court will say preponderance and probabilities. The same principle applies to the insurer also, who had no notice of, my lord, as required under section 134C, and the investigating officer, my lord, has not supplied the document as required under section 158(6). Only after service of, my lord, the claim notice, the insurance company comes into this thing. But anyway, the sketch, my lord, shows that there was a pedestrian crossing.
Correct.
So if somebody, my lord, all of a sudden not across the road, can it be said, my lord, it is due to the negligence, whether it was the motorcycle rider or the, my lord, injured or his father? Therefore, my lord, under these circumstances, my lord, this type of claim should not be encouraged by the court of law. And moreover, what has been claimed as the income, my lord, has not been proved. And when the injured has not entered the witness box, my lord, an adverse inference has to be drawn both on question of, my lord, the manner of accident and also his avocation and alleged income. Even what has been granted by the tribunal is without any basis.
What is the age of this?
17 years at the time of the accident, but during the trial, my lord, he has attained the majority and he has not entered the witness box. Mother has been, my lord, has entered the witness box. Admittedly, she is not an eyewitness.
Why you did not examine the claimant?
At the time of giving the evidence, my lord, he is not completed 18 years.
What is the age proof you have produced of claimant?
Nothing.
I can't produce either proof, my lord.
Why?
At the time of accident and.
No, you have said that
Evidence
he,
of-
no, you have said that he is a student of PUC. So if he's student of PUC, if he's 17 years, when was the evidence recorded in the case?
Mother PW1, my lord,
In 2018.
on 20th of July 2018, she was examined.
So accident took place in 2017.
Date of disposal, my lord, is 11/7/2019.
That is okay, as on date of producing the evidence. Question is whether he had attained majority.
Yes. During the course of the trial, my lord, he has attained majority. He was shy to enter the witness box because the disability, my lord, said to have been claimed would be out of, my lord, this thing. Therefore, my lord, they keep the, my lord, injured out of the witness box.
All right, I will send it back to the tribunal. You won't examine.
Yes, let them, my lord.
Examine
Yes,
your client, that is the young boy student,
yes.
whatever he may be.
Regarding his
Whatever.
education and income also has to be.
Second thing is, why you have not examined the prime witness who was the father of the boy who was, according to you, riding the vehicle?
I am the pillar rider of the vehicle. Another case, my lord, in 304A, the pedestrian was a rider in that accident. He also paid one more claim petition. Claim petition was allowed.
Yeah, ಕೊಟ್ಟಿಲ್ಲ ನೀವು. So that pedestrian has died in the accident.
Yes, ma'am.
So that criminal case, who was accused in that?
It is the father of the petition.
ಅದೆಲ್ಲ ಕೊಡಬಾರ್ದನ್ರಿ ನೀವು.
Nothing is placed on record.
Now that clinches Mr. Mahesh.
Yes,
In view of the criminal case of 304A filed against the father,
but mere filing of Malad charge sheet does not indicate Malad this thing unless they have proved it. Therefore, Malad,
they are not deciding proof beyond reasonable doubt in a motor vehicle.
let them Malad, let the matter be remanded, let them Malad produce the document, the proof.
You go before the tribunal, examine your client, examine the father,
Yes.
produce our materials. When you do a case, you should.
As per the FIR and the charging, my lord, it's mentioned in the 304A. And also is guide in the pedestrian was died in that accident.
But suppose Malad, the father has been acquitted.
That acquittal doesn't make much of a
No,
difference.
Malad, that's why Malad, what I am saying is, normally in the criminal courts, Malad, they see that Malad, witnesses are not, available or not examined, then there will be an acquittal.
That is why
Yes, that's why, Malad. Yes, father, let them Malad examine the father. Let us see.
Yes, you will also be given an opportunity to cross-examine
We'll
both.
also, Malad, we'll also, if they fail to do it, we'll do it.
I send it back, remand it, both of you can adduce evidence
Yes.
and cross-examine each other. Issue appeals are preferred in the judgment and award of the motor vehicles claims tribunal Bangalore City CH-4 in MVC 502 of 2018. The appeal preferred by the claimant on account of inadequate and meager compensation awarded by the tribunal. Whereas the appeal preferred by the insurance company is on the ground of false and frivolous case filed by the claimant, and exorbitant compensation awarded without taking into consideration the materials placed on record. The facts of the case are as under. According to the claimant, say to 17 years, a student represented by his natural guardian, the mother, Gazi Mario. Claimant was traveling as a pillion rider along with his father, who was riding the motorbike bearing registration number A04JL1050. When the motorcycle bike reached near Kuampu Nagara main road behind Kariyamma temple, the rider of motorcycle is the father of claimant, rode the motorcycle in a rash and negligent manner and dashed against a pedestrian who was crossing the road. Due to the impact of the accident, the claimant sustained grievous injuries. He was shifted to Rajalakshmi Hospital, Bengaluru for treatment, where he was inpatient for 5 days. And he spent more than 2 lakh rupees towards medical treatment and other incidental expenses. In view of the injuries sustained in the accident, claimant filed claim petition seeking compensation against the respondents. That is the insurance company, respondent number 1, and owner of the vehicle, respondent number 2, who is none other than the father of the claimant himself. Respondent number 1, insurance company, filed statement of objections. However, respondent number 2, despite appearance before the court, did not file any statement of objection. On the basis of pleadings, tribunal framed relevant issues for consideration. Mother of the claimant, representing the claimant as a natural guardian, examined herself as PW1. As when the claim petition was filed, it is stated that the claimant was aged 17 years and studying in PUC, that is pre-university. As being a minor, the mother represented as a natural guardian, examined herself as PW1. Got marked exhibits P1 to P13. The doctor also was examined as PW2. Respondent examined one doctor, the hospital, as RW1 in their favor. Produced the NLC police intimation as exhibit R1. The claimant sought for allowing the claim petition, whereas the respondent insurance company sought for dismissal in the grounds urged therein. Tribunal, on the basis of consideration of materials placed on record, awarded compensation of 3,07,000 with interest at 6% per annum, and directed the first respondent insurance company to pay the compensation within 30 days from the date of the order. Stop paragraph. Being aggrieved by the meager compensation awarded, claimant is before this court seeking enhancements. Whereas the insurance company has questioned the very same judgment on the ground of it being arbitrary and erroneous. To set aside the same as a false and frivolous case has been put forth by the claimant in collusion with his father, respondent number 2. It is the vehement contention of learned counsel for the claimant. The tribunal has committed an error in awarding reasonable compensation, ignoring the evidence adduced by the parties with regard to assessing the notional income and applying the disability as opined by the Dr. PW2. And he contends that the judgment rendered by the tribunal requires modification by enhancing the compensation. By contra, learned counsel Sri Mahesh, representing the insurance company, vehemently contends that the case put forth by the claimant is frivolous, false, and concocted. According to him, the claimant himself was riding a motorcycle. And due to the negligence of the pedestrian, the accident occurred and there was no rash or negligent riding by the rider of the motorcycle, which is insured with the insurance company. He also contends that the claimant, who is stated to have been a minor as on date of filing of the claim petition, had attained majority as on the date of adducing evidence. Therefore, nothing prevented the claimant stepping into the witness box to narrate the incident which he had seen by himself as an eyewitness. It has not been done. The mother has stepped into the witness box, who has admitted to the fact that she has not seen the accident and was not an eyewitness. So also the claimant has not examined the other best witness to the incident, that is the father, who's respondent number 2, and thereby suppressed material facts. Hence the judgment and award passed by the tribunal requires to be set aside. The claim petition requires to be dismissed. Stop. Having heard learned counsel for the claimant and learned counsel for the insurance company, the occurrence of the accident, involvement of the vehicle is not much in dispute in view of production of the exhibits from the police records, that is P1 to P8. However, there is some force in the submissions put forth by learned counsel for the insurance company as to why the claimant did not present himself for recording his evidence, as he would have been the best witness to narrate the incident before the court as to what happened on that fateful day. Without getting into the aspect of the correct age or the attaining of majority, an opportunity now requires to be given to the claimant to adduce his evidence, because now he has attained majority. So also, claimant has not examined respondent number 2 would have been the best witness in his favor to narrate or corroborate the evidence of the claimant with regard to the occurrence of accident and the events that unfolded on the fateful day. So also, nothing prevented the insurance company from examining the respondent number 2 by summoning him as a witness, even though he has not been examined by the claimant as a witness, elicit the truth before the court. All these aspects have not been undertaken before the tribunal, and it would become difficult for this court to analyze the evidence which are not before the court. There are certain gaps in the evidence for non-examination of these witnesses. And without adverting to the merits of the matter with regard to the injuries suffered, the causation of the accident, the rashness and negligence, the court deems it appropriate to remand this matter back to the jurisdictional tribunal for evidence to be conducted. Further, so that the claimant can establish his case by adducing any further evidence of himself or any other witness, including respondent number 2. And so also liberty requires to be given to the respondent, both the respondents, including the insurance company, to examine any further evidence and cross-examine the witness of the claimants. Under the circumstances, without expressing any opinion on the merits of the matter, I deem it appropriate to remand this matter back to the jurisdictional tribunal. Accordingly, I pass the following order.
Date of appearance may kindly be fixed.
Yes, yes. Our appeal member could. Before the appeal preferred by the claimant is disposed of, remanding the matter back to the jurisdictional tribunal for conducting of a fresh evidence. Appeal preferred by the insurance company is allowed. The judgment and ward passed by the so-and-so is hereby set aside. Matter is remanded back to the jurisdictional tribunal for fresh evidence by providing opportunity to the claimant as well as the respondents to produce evidence and cross-examine the witnesses. It is made clear that this court has not expressed any opinion on the merits of the matter. All contentions are left open. Both the parties, learned counsels are present before the court. The parties to the proceedings shall appear before the jurisdictional tribunal on No. After a month, you give a date.
Records have to go back.
March.
Ah.
26th March.
26th March, I'll give a date, Mr.
Yes,
Mahesh. 26th तारीख 26th March 2024.
24, please.
26th March. Both the parties, all parties. Here, the father is served.
Yes,
Yes.
All parties. all parties, along with the respective counsel, shall appear before the court without awaiting any further notice, either from the trial tribunal or from this court. The original
Madam.
records shall be
Madam.
transferred.
Amount deposited by the insurance company be sent to MACT, which will be subject to the result of the Manod.
The original records shall be transmitted to the jurisdictional tribunal forthwith. The amount in deposit made by the insurance company shall be transmitted to the jurisdictional tribunal, which shall be kept in a fixed deposit in a nationalized bank. And the same will be subject to the outcome of the judgment of the tribunal.
Please.
29. KP Gurudev Prasad.
ನೋಡಿದ್ರೇನ್ರಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇವಾಗ ಗೊತ್ತಿದ್ಯಾ? ಅದು ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ. ಹಾ. ಅದು ನೀವೇನ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ? ರಿವರ್ಸ್ ಇಂಜಿನಿಯರಿಂಗ್ ಮಾಡ್ಬೇಕಿಲ್ಲಿ. ಇದು ವಕೀಲರಿಗೆ ರಿವರ್ಸ್ ಇಂಜಿನಿಯರಿಂಗ್ ಇದೆಯಲ್ಲ, ಅದು ಮಾಡ್ಬೇಕು. ವಾಟ್ ಇಸ್ ಮೀನಿಂಗ್ ಆಫ್ ರಿವರ್ಸ್ ಇಂಜಿನಿಯರಿಂಗ್? ರಿವರ್ಸ್ ಲಾಯರಿಂಗ್ ಅಂತ ಮಾಡ್ಬೇಕು. I was giving a lecture the other day in the district Chitradurga. A person who conducts trial before the magistrate court or trial court without knowing what is happening in the high court or the flaws, he will conduct thinking everything is correct. When you come and sit here, you will know what are the flaws that is committed. So after sitting in first appellate court and high court, you will realize that what is the flaw you have committed. So you have to go backwards. So now you know what is the flaw committed by you, your client, and the counsel. So you have to rectify that. So also by the counsel for the insurance company. Yes. Why, sir?
We have asked for the details for that purpose, I believe next week.
You have the number? Gurudev is not here. At request of learned counsel for respondent. He is next week. Called ಆಗಿದೆಯಲ್ಲ, PCR to be called. To be called. To be called, not yet called. Registry to secure TCR. Chandra Shetty. Shankar. Ready, na?
Yes.
What is your name? Swati.
Yes, 14. Date of action is 14.
ಅವ್ರಿಗೆ ಹೆಸರು ಕೇಳಿದ್ರೆ ನೀವು 14 ಅಂತಿರಲ್ಲ.
One year afterwards,
Accident occurred on 2/1/2014. Yes, inpatient T3/2014. 38 days, my lord, he was inpatient. And after 1 year, my lord, he died.
1 year.
He was in coma, but after 1 year, he was dead.
He was diagnosed to be in coma.
Yes, my lord, we examined doctor and to establish
there is no dispute between the death and the incident. They are not very happy. They are satisfied about only on the quantum divided. The sentimeter, because we are not disputing. We are not very happy. We are repeated. Just because 8,000 is taken very.
Yes. So now you have heard what he said.
Yes,
So you can proceed further. Don't go backwards.
yes. My lord, he was 45 years at the time of death.
45.
Yes, my lord.
Not disputed.
And doing self-employed.
46.
46. Change ಆಗುತ್ತಾ ಅದು?
Okay, then 1 year after the period. Data back in front of my.
Right.
So he is very like, injury case for the petition before the court. He only filed and subsequently died. And we need a
So multiplier will change. That's
that is will become. Yeah, we do not also.
yes.
And the dependents are wife and children's account.
Hmm.
And the income taken was 8,000 by the tribunal.
Hmm.
Accident my lord 2014.
Hmm.
As per chart, my lord 8,500. Consortium. Purpose of consortium only 40,000 was awarded by the tribunal.
Forty-eight. Tribunal has taken his age as 48, is it?
Right of that 46 also, 13. There is no difference between the
46 to 50 it will be.
That's why I am
8,000. Yes, 8,000 income.
500 rupees only the airport. Multiply for the 30. And convention rates your Rajit 13th, 70 I think about. I think as per the regulations. Whatever the region. I think
Yaudake.
That's consumption and convention rates. Because 50 is awarded to come to 70%. And your lordship, over the consulting and.
Yes, ma'am.
Consortium, only right for, they give only 40,000 for consortium, with unmarried children's.
Hmm.
1,000 each may be kindly considered.
So other limit objection illa. Because you have not preferred any appeals.
That's why I have already said that before it also, you do not get.
So what is added, how much is added by the tribunal? Future prospects. Future prospects is put together.
20% of the amount taken.
Deduction est ಮಾಡಿದ್ರು.
You want to write it?
1/4.
Discussion 1/4, that is also right. Your lordship can.
30, 32, 33,
Discussion is like. It will be
33.
20%, 500 rupees, 25% added.
25% they added and for 1/4 will be passed, direct termination.
Okay. It's only
Income minor.
500 rupees ಜಾಸ್ತಿ ಆಗ್ಬೇಕು. Like what Mr. Ravi Shankar said.
Consortium will.
Oh.
Other very kindly consider my brother narration food attachment.
That is already awarded one of that.
But my.
Cannot be done with that.
1 year.
Cannot be done.
And 38 days.
What is the material you have produced?
We produce the medical expenses and we examine the doctor.
Medical expense ನೀವು ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಅಲ್ವಾ ಇದು ಕೊಟ್ಟಿರೋದು?
We examine the doctor, treated doctor.
Hmm.
He stated, my lord, he was in inpatient 38 days and he was in coma. This is my lord, running page number 21, para 27, my lord. For our parallel last bottom like that. 372 days.
Medical expenses are given.
As it is.
All right. So he was inpatient, medical expenses given. Food nourishment is also given. So what else you want? Huh?
1,56,000, 1,15,000 and this one, conveyance, everything is awarded.
ಅದನ್ನೇ what else you want ಅಂತ ಕೇಳ್ತಾ ಇರೋದು.
You want to learn it is awarded.
Whatever.
Consortium and the income, my lord.
He is agreed, madam.
Yes,
He says you can increase 500 rupees as per the chart.
yes, my lord.
The
125 is added.
future prospects ಕೊಟ್ಟಾಯ್ತು. 1/4 deduction ಆಗಿದೆ. Consortium has to be increased.
With regard to attending charges, my lord, If we kindly increase, my contention may be recorded. Because my lord, he was inpatient 38 days and 372 days, my lord, he was in coma. Because of that, my lord.
372 days.
For that, my lord, we examined the doctor.
What about that period of being inpatient, Mr. Ravishankar? What about that period during the inpatient for almost 1 year when he was in coma?
But they are not producing the other material to show that they are taking the treatment for admit to the hospital. That has to be given to what then they will award them. That's why attendant other charges 1,60,000 is awarded.
Food
Now,
nourishment.
go back to the one they are doing definitely entitled for that. But as for the attendant nourishment is 1,60,600 already getting.
These are the discussion 1 lakh.
90 page judgment page 90. Page number 19 of judgment.
I have 19.
Yes, sir. Paragraph 35.
Hmm.
11 lakhs 70,000 in dependency, medical expenses fully awarded.
No. Where is the discussion for our awarding?
Running fees for
Discussion from the legal
paragraph 27.
subsequently, right now, the only the discussion is coming in the.
May I permit you to read? my lord?
Yes, 27.
The accident took place on 2/1/2014. In the said accident, the injured petitioner sustained various injuries to his head and he was unconscious on the date of accident. However, he died on 8/1/2015. While answering issue number 2, it was held that the deceased petitioner died due to the injuries sustained in the alleged accident. On perusal of the inpatient bills and case sheets and also evidence of PW2, it is no doubt that initially the deceased petitioner was admitted in high-tech medical hospital on 2/1/2014 and he was discharged on 3/2/2014. Again, he was readmitted to the said hospital on 24/12/2014 and discharged on 1/1/2015. These medical documents disclose that the deceased was bedridden from the date of accident till his last breath on 8/1/2015. As noted above, the accident in question took place on 2/1/2014 and deceased Pichandi succumbed to injuries on 8/1/2015. That means almost 372 days deceased was bedridden and unconscious. Out of 372 days, deceased was in hospital for a period of 38 days.
370 days per day 300 rupees awarded per day for 372 days. What more else is awarded? 300 rupees per day awarded. And 5,000 for the conveyance also awarded. 1,60,000 that will come. Three 72 days into 300. All days covered. What else you are? They calculated it all the same.
Yes. The calculation of even if you make 8,500 into 12 months, you get lesser than what is awarded by the court.
Yes.
If even if this court comes to a conclusion that you did not do any work and no income for 1 year, 365 days, less than 38 days.
96 already we know.
Attendant charges. Is in coma, my lord. One person should be attended to him. Attendant charges may be kindly increased. For coma patient, my lord, for food and also nourishment, my lord, we have to be in treatment.
This appeal is preferred by the claimant. Questioning the judgment and award of the senior civil judge and additional MSCT at Udupi. MBC 133 of 2014. The facts of the case. Claimant was standing by the side of the road to cross the road near Abaran Motors, Nitturu, Udupi. And the driver of tempo bearing registration number KA20C7669 rode a tempo in a rash and negligent manner and dashed against the initially the claimant was standing by the side of the road, as a result of which the claimant sustained grievous injuries and was admitted to high-tech Medicare Hospital Udupi, where he was inpatient till 3/2/2014. The claimant sustained severe grievous injuries, major fracture, and also injuries to his head and other parts of his body. Despite the best treatment in the hospital, he lost his complete consciousness. And he was discharged on 3/2/2014 with advice for special care and attention. Thereafter, the claimant was readmitted to the hospital once again, but before that, he filed a claim petition seeking compensation for the injuries sustained and the financial expenditures met. So, respondent number 1 did not appear, he was placed ex parte. Respondent number 2, the insurance company filed statement of objection denying the claim of the claimant, including age, avocation, income, and the negligence attributed against the driver of the offending vehicle, and sought for dismissal of the claim petition. At the time of the claim petition, it was amended to death case
Of the death of the.
before the tribunal itself.
Tribunal is of the death. The tribunal is amended.
During the pendency of the claim petition before the tribunal, and the treatment being administered, the claimant succumbed to the injuries despite best treatment administered. And accordingly, the claim petition came to be amended for claiming compensation for the death having occurred due to the occurrence of the accident. Thereafter, the claimants are the legal representatives of the deceased, Chandi, the unfortunate widow and 3 children, got impeded. Evidence came to be adduced. PW1 and PW2 examined on behalf of the claimants. Exhibits P1 to P11 came to be marked. Respondents examined two witness RW1, RW2 got marked exhibits R1 to R3. On the basis of materials placed on record, both oral and documentary, tribunal, on hearing the counsel for both sides, awarded compensation to an extent of 15,13,500 rupees with interest at 6%. And directed respondent number 2 paid a compensation within 45 days. So being dissatisfied with the meager compensation awarded by the tribunal, the claimants are before this court seeking enhancement. I've heard the learned counsel for the claimant and the learned counsel for the insurance company. There was the impugned judgment and award. And the documents exhibited at exhibit P1 to P11. There's not much of a dispute with regard to occurrence of accident, involvement of the vehicle, injuries sustained by the deceased, and thereafter succumbing to the said injuries. And in the meanwhile, the deceased had gone into state of unconsciousness during a period of 372 days, pursuant to which he died. Therefore, negligence is rightly attributed as against the driver of the offending vehicle. The only point for consideration before this court is whether hanging para. The claimants are entitled to enhancement of compensation. If so, what amount? Tribunal has assessed the income of the claimant, the deceased, income of the deceased to be 8,000 per month, as no documentary proof came to be produced regarding proof of income. However, the Legal Services Authority chart for the year 2014 describes an income of 8,500 per month. Hence, income is taken at 8,500 as against 8,000. Claimant is said to have died at the age of 46. Taking the age of 46, the appropriate multiplier would be 13, which has been adopted correctly by the tribunal. Hence, the multiplier is taken at 13. Due to the fact that the claimant was aged 46 years, he would be entitled to 25% future prospects. Same is added by the tribunal and is this retained. And there being 4 dependents, 1/4 is deducted towards personal and living expenses, which is also retained. However, what changes is the income which is taken at 8,500. Therefore, the loss of dependency would be 8,500 plus 5%. 0.625 divided by 4. 56. So 969 to 12 to 13. 1,43,164. Correct, Emma? 1,43,164 would be the loss of dependency as against 11,70,000 assessed by the tribunal. Medical expenses has been awarded at medical expenses has been awarded at rupees 1,56,536 on the basis of actual Bills produced by the payments, same is awarded and it is retained. Towards food, nourishment, attendant charges, conveyance, the tribunal has awarded 1,16,600. Same is retained. This amount has been taken considering the fact that the claimant was impatient and was in a state of coma for a period of 372 days. I do not find any reason to interfere with this. Towards loss of estate, 15,000 is awarded. Towards funeral expenses, 15,000 is awarded. It is retained, but an additional escalation amount of 10% would have to be added to this of 3,000 concerns to the judgment of the case, in the case of Pranay Sethi. Towards consortium, tribunal is awarded 40,000 for one person. If there are 4 dependents, each would be entitled to 40,000 per person. Therefore, 1,60,000 is awarded under this head. The escalation of 30% towards one block period of 10%. 30% escalation. 10% per one block period.
16,000 and 16,000.
No, on 40,000.
42,000.
40,000 के 10% are
44,000.
44,000. So in case of this 4%, 1,60,000.
Already satisfied.
Maybe what is satisfied, you have to minus that, that's all. 1,60,000 into 30%. 48,000 is awarded as escalation in consonance to the judgment of Pranay Sethi. Stop. If the above discussion, claimant will be entitled to total compensation of as against 15,13,136. Accordingly, pass the following order. It is partly allowed. Judgment is modified. Claimants are entitled to total compensation of rupees 17,57,300 as against 15,13,500 with interest at 6%. Enhanced compensation with interest at 6% shall be paid within a period of 4 weeks from the date of receipt of copy of the order or other terms fixed by the tribunal with regard to apportionment, and FD remains intact. Enhanced compensation shall be released in favor of the claimants upon proper identification. Idea.
No, interest for the delay.
Yesterday.
168 days.
Control
Order sheet, order is here.
How is there?
There is order. On 68 days. Claimant shall not be entitled for interest for the delayed period of 168 days. Yes, Mr. You are ready? Yes. Okay.
7/4/2017.
The case of Sheena,
Yes, Your Worship.
149. Yes, what is the date of accident?
7/4/2017.
Hmm.
He was working as a masonry.
Hmm.
He was inpatient about 33 days. The injuries is discussed in para 28, running page number 29.
Nimden appeal illalla. So no dispute. No, with regard to occurrence of accident and involvement of the vehicle, there is no dispute. Maybe you may have on quantum. Page 29.
Page 29, para 28.
Yes,
May I continue?
yes, yes.
The petitioner in MVC number 749 of 2017 has sustained contusion on lower part of left side of the chest, which is simple in nature. Laceration on lower 1/3 of right thigh with X-ray showing
Right thigh.
Yes, Manoj. Right thigh with X-ray showing commutate fracture of humor, laceration on right heel with crushing of muscles and tendons laceration on the right big toe with near total amputation, which are grievous in nature. PW3, Dr. Ullas Shetty, Assistant Professor and Forensic Medicine and Technology Department, AG Hospital and Research Center, Mangalore, has deposed that the petitioner was treated in their hospital for the accidental injuries. Therefore, this is the injury. We
What is the age?
produced
What is the age?
41 years.
What is the disability?
Doctor states, my lord,
What the tribunal has taken? 40?
Yes.
7?
47. But they are 30.
Mhm.
Doctor assessed permanent disability of 59% to right lower limb
Hmm.
and amputation of toe.
Amputation of
Big toe.
big what?
Big toe.
Toe.
Yes,
Oh, toy alla.
big toe.
Amputation.
Yes, my lord. My lord, we produced the photograph such.
Okay. And what was he working as?
Working as a masonry man.
Mesri.
Yes,
But notional income is taken.
yes.
How much is taken?
My lord, accident was, my lord, in 2017, but 12,000 was taken.
12,000 was taken by the tribunal.
Yes, my lord.
So you have given more. You are not in appeal? In kadinda appeal done. All right, so 12,000 income.
And tribunal taken 20% to the whole body.
Hmm.
Is it?
But what the doctor has said.
The only statement of 59% to the right lower limb.
Hmm. Hmm. Yes, madam. The injuries are in para number 28.
28.
They are simple in nature. We produced the photographs. Records with you. All right,
My lord, executive 34.
I don't have, give it to. The 20% per even according to that employees compensation schedule. %% is taken for the whole board. Yes. What about other heads?
Parents are paying 60,000, lots of communities 30,000.
ಅವ್ರಿಗೆ ಹೇಳಿ ಬಿಡ್ರಿ ಆಮೇಲೆ ನೀವು ಮಾಡಿ.
My lord, doctor assessed 59% to the link, my lord.
That you have said already.
Yes, my lord, tribunal taken 20% of the
Whole body.
whole body disability. As a history, my lord, he was not able to do his work, my lord. For 60%.
All right. Come to the other heads.
Other heads, my lord, pain and suffering 60,000 was awarded, my lord. Loss of amenities 30,000 was awarded. My lord, loss of amenities is paid by me.
How many days inpatient? 33.
33 days.
40 days. Medical expense actual?
Yes,
Fully
my lord.
awarded.
All right. Future medical expense ಕೊಟ್ಟಿದ್ದಾರೆ. Yes, Mr. What's your name? Sunil Kumar, yes. All right. What is your argument?
It's a correct idea. What are the amenities are very 20?
So, according to you, only area that calls for is amenities.
So, 11,000 to 100,000. This charge was 33 days, so 40,000 to be.
ಇಲ್ಲ ಜಾಸ್ತಿನೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವ್ರು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ.
Doctor said, my lord, restriction in activity range.
59% to the limb.
Yes,
He's a Maestri. So that right toe is not going to hamper him.
but my lord, shortening is there, my lord, 3 centimeters.
Oh, madam. How you are going to say it is better, even according to the schedule of the Employees Compensation Act?
Still, my lord, he is in difficulty in marking, climbing upstairs, marking.
ಡಾಕ್ಟರ್ದು ಎಲ್ಲ ಹೇಳ್ತಾರೆ. ಒಂದೇ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ವಾಕಿಂಗ್, ಕ್ಲೈಂಬಿಂಗ್, ಸಿಟ್ಟಿಂಗ್, ಸ್ಕ್ವಾಟಿಂಗ್. But this filed in the year 2021. But this appeal is preferred by the claimant.
Total amount 7,20,000.
It is preferred by the claimant in the judgment and award of the civil judge MSCT Karkala in MVC number 749 of 2017. Ground of inadequate and meager compensation awarded by the tribunal. The case of the claimant that accident occurred on 7/4/2017. While the claimant was a Indian rider, a motorcycle bearing KA 19 ET 4926. When they were riding the two-wheeler and reached near Kari Marukatte of Daru village on Tata XCNON LMV vehicle bearing registration number KA20C8420 came in a rash and negligent manner and dashed against the two-wheeler, resulting in the accident. The short point for consideration in this case, whether a claimant is entitled for enhancement of compensation, if so, what amount? There is not much of a dispute with regard to occurrence of accident, involvement of the vehicle, injuries suffered by the claimant. So also the disability which is awarded by the tribunal. I've heard learned counsel for both the parties, that is claimant as well as the learned counsel for his insurance company. Here's the impugned judgment and award. The tribunal has passed a recent order awarding just and reasonable compensation to the claimant. Our learned counsel for the claimant seeks enhancement in few of the areas, attending that the tribunal has committed an error in granting lesser compensation under loss of amenities. Taking into consideration the overall evidence adduced by the parties and the injuries sustained by the claimant and his occupation, the compensation appears to be quite reasonable. Our global compensation enhancement is made, awarding rupees 50,000 in excess to 7,19,325 on the head of loss of amenities and loss of amenities. In view of there being the amputation of the right toe, accordingly, I pass the following order. It is allowed in part. Claimant is entitled to. Judgment is modified. Claimant is entitled total compensation of 7,69,325. Interest is awarded at 8%, along with the interest at 8%. However, enhanced compensation shall carry interest at 6%. It shall be paid within a period of 4 weeks from the date of receipt of copy of the order. Claimant shall not be entitled to interest for the delayed period of 347 days. ಏನ್ ಬಂದಿಲ್ಲ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್? ಫೈನಲ್ ಕಾರ್ಡ್
7%.
Tribunal has taken 7%. What was the avocation? ಜಾಸ್ತಿ ಕೊಡಬೇಕಾಗುತ್ತೆ. Spinal cord is the load bearing entire thing. Everything depends on the spinal cord for a human being.
The calculation of compensation that regarding the percentage of disability issue question. Regarding that money submission is there. Okay, as per the field of the truth, they are not evidence.
Ramakumar.
Orthopedic surgeon in Ramakrishna Hospital, 2016. One engaged 38 years, 19 at Ramakrishna. That's number from 2017 to 26/4/2017 as an inpatient and the following. Without neurological devices. But regarding the doctor's statements, the clear they have delayed on the disability assessment is calibrated as per the guidelines which should be getting notification. BGHS Government of India dated June 2001. Regarding the my submission, the disability certificate assessment is calculated by the doctor is the judicial evidence. And when in any case if we produce photograph also, when we carry photographs and doctor certificate, the evidential value of doctors this disability certificate carries more weightage because he is expert in that. The Indian evidence and this is the best piece of evidence for calculating the disability in my submission. 20% is 20% disability calculated. doctor is 20%, we can consider it.
So we can take 20%, but tribunal has taken 7%.
The issue, we have discussed 7%, but in calculation sheet, they have considered 20%.
ಹೌದಾ? ಹಾ? ಮತ್ತೆ ಇನ್ನೇನು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಿದೆ? ಮೇಡಮೇ ಮಾಡಿದ್ದಾರೆ. ತಗೊಂಡಿರೋದು 20% ಮಾಡಿದ್ದಾರೆ. $7,000 into 12 into like 52 after deduction of 20% ತಗೊಂಡಿದ್ದಾರೆ ಮಿಸ್ಟರ್ ಶಾಂತರಾಜ್. ಅಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 13 ಅಲ್ಲಿ 7 ಹೇಳಿದ್ದಾರೆ. But while calculating in para 15, 20% is taken.
7,000 income.
Income ಎಷ್ಟು ಬರಬೇಕು?
13 lakhs ಇದೆ. Yes, sir. 15,000 claim ಮಾಡಿದ್ದಾರೆ.
So then income has to get increased, madam.
Rate of taxing is 2,000.
18,500.
I per charge 11.
It is English.
What is the age?
50.
Multiplier? Fifteen. You rely, ಇದರಲ್ಲಿ ನೀವು ಆ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ರೇನು? You relied on the judgment of his lordship Justice Bhatt. ಇದರಲ್ಲಿ ಇಲ್ವಾ ಅದು? What is the evidence of the doctor? Has he said doctor that she cannot do the work ಅಂತ ಹೇಳಿದಾರ? Yeah, but it's not supported. Are you intending to produce the photograph, Mr. Shantara? If you cannot, then we'll proceed further. ಇಲ್ಲ ಫೈನಲ್ ತೆಗಿಯಕ್ ಬರಲ್ಲ, ಬಟ್ ಇಫ್ ದರ್ ಇಸ್ 20% future prospects is, are you seriously arguing for future prospects?
ಯಾಕೆ ಅಂತಂದ್ರೆ
ಇಲ್ಲ.
ಇದು is a nation affect his capacity.
Mason by profession. That is not nothing. You cannot prove that. Such a the unskilled sectorly young prove ಮಾಡೋದು.
What more documents can you expect by the tribunal also? ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಶಿವಕುಮಾರ್ ನಮ್ಮ ಇಟ್ಕೊಂಡಿದ್ದು 2017 5SCC A79 ಇದೇನಪ್ಪ PMPC ಅದರಲ್ಲಿ ಮೀಟರ್ ಅವನು 15,000 ಬರ್ತಿತ್ತು ಅಂತ ಕ್ಲೈಮ್ ಮಾಡಿದ್ದ. ಟ್ರೈಬ್ಯುನಲ್ ಹ್ಯಾಸ್ ಟೇಕನ್ 15,000 to 14 actually.
So what do you say on the future prospects?
Doctor's evidence clearly shows that patient was admitted for the treatment for above mentioned injury. When he underwent conservative treatment as per the medical instrument, is the conservative treatment is compared to fracture. He was discharged with an advice to follow regularly on an outpatient basis. I recently examined the patient for disability assessment and the following observations are made. Mark union of fracture noted in the of fracture stage and
Malunion is not united. Malunion means it is not united. Oh, then right. Otherwise, it is a united. They will see. So it's not one. It is T6 and T12. Restriction of spine movements. Restriction of spine movements.
are united
To call for future prospects. To call for future prospects. Fundamentals of this legislation is to put back the claimant in the original position as he was prior to the date of occurrence of accident. That is what the Supreme Court and this court has held in several times. I will take down your contentions. Anything else you want to argue? That tribunal is taken 20. Go with the future prospect. What called? See, spinal injury. One, it can be physical disability of the body. Secondly, it can affect the neurology. Neurology means then you become vegetative state. You can go into paraplegia also. So that has not happened at the doctor level. It's not 100%. This appeal is preferred by the claimants. Questioning the judgment and award of the tribunal, MACT Claims Tribunal, 3rd Additional District, Karnataka, in MVC 233 of 2017. The case of the claimant that he was a passenger in KSRTC bus carrying registration number KA09F5136 traveling from Bengaluru to Ramnagara. When the bus was driven by the driver in a rash and negligent manner, while negotiating the road humps, due to the rash and negligence driving of the driver of the bus, the claimant, who was the passenger in the bus, sustained injuries to his backbone. He took treatment in the Ramakrishna Hospital, where the X-rays revealed that 3 bones of his spinal cord were fractured, and he took inpatient treatment for more than a month, incurring expenses of 1.5 lakhs. Due to the injuries suffered and the mental pain and agony and trauma, he filed claim petition seeking compensation against the respondent corporation. Written statement came to be filed by the corporation, and on consideration of the materials placed before the court tribunal, compensation of 3,76,000 came to be awarded by the tribunal. Being aggrieved by the meager compensation, claimant is before this court seeking enhancement. I've heard the learned counsel for the claimant, Sri Shantaraj, and learned counsel for the corporation. The Reserve Bread better corporation early, because I don't know where he is now today for the corporation. The occurrence of the accident, involvement of the vehicle, injuries suffered by the claimant are not much in dispute. So also the same is evidenced by production of exhibits P1 to P61, police records and the medical records. The claimant is before this court on the question of income assessed by the tribunal on the lower side, 7,000, whereas the Legal Services Authority chart prescribes 11,000 for the year 2017. So also it contends that in view of the serious disability of 20%, the whole body, and 59% to the single vertebra, future prospects would have to be awarded. Learned counsel for the corporation vehemently controverts the arguments put forth by learned counsel for the claimant, contends tribunal is awarded just and reasonable compensation, which does not call for interference. She also contends that the doctor PW2 has been examined, who was given stating that the disability is only to an extent of 20%. As a question of awarding future prospects would not arise, as she can do any other work and activities. On a careful perusal of the evidence adduced by the doctor and the injuries sustained, it is apparently seen that the claimant has undergone injuries to the vertebra, spinal cord, involving the spinal cord of T6 and T12, and the doctor has clearly opined there's a restriction of spine movement. And the X-ray shows is malunited vertebra fractures. Therefore, the evaluation of the doctor with regard to the restrictions in the spine movement will directly affect the claimant in performing his day-to-day activities with the avocation of him being a mason. Therefore, with the court is of the opinion that in the special facts and circumstances of the case, future prospects would have to be awarded. Tribunal having taken the income at 7,000 is also on the lower side. I'm in agreement with the learned counsel for the claimant that same would have to be enhanced to 11,000 per month. Therefore, taking the income at 11,000 per month, and the age of the claimant being 38, 38, 40% would have to be added towards future prospects. Should be 15,400. into 12 into 15 be 27 lakh 27 lakh 72,000 into disability of 20% be 5,54,400. As against. So ತಗೊಂಡಿಲ್ವಾ tribunal has not taken it. ಇದೆ as against 2,52,000. It's against 2,52,000. Towards pain, agony, on account of fracture, tribunal is awarded 60,000, same is retained. Towards medical expenses, attendant charges, food, nourishment, 17,000 is awarded, retained. How many days you are inpatient? It is retained. What's loss of income during lead-up period? 42,000 is awarded, same is retained. Towards conveyance, 5,000 is awarded, it is retained. Tribunal has failed to award the loss of amenities, considering the fact that the claimant has sustained severe injuries to the spinal cord, that is T6 and T12. 50,000 is awarded under this head. Of the above descriptions, claimant would be entitled to total compensation of 7,11,400 as against 3,76,000 with interest at 6% per annum. Accordingly, I pass the following order. Appeal is allowed in part. Judgment is modified. The claimant is entitled to total compensation of 7,11,400 as against 3,76,000 with interest at 6%. Enhanced compensation shall be paid within a period of 4 weeks with interest at 6%. Are you satisfied with the amount? Satisfy ಮಾಡಿದ್ದೀರಾ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಮಾಡಿದ್ದೀರಾ so enhanced balance amount has to be given. The enhanced compensation shall be paid in a period of 4 weeks from the date of receipt of copy of the order. Entire amount shall be released in favor of the claimant. Yes, other matters I think may not reach. So we'll call out any dates you want, you can take.
Their officers put a note saying that the round seal is not forthcoming on the certificate copy of the judgment you're actually. Even I need to secure otherwise set up certificate copy.
Stay ಆಗಿದೆಯಾ ನೀವು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ
34.1 is the appeal filed with the insurance company.
all right, stay is granted, so you file that.
Yes. Filing with the
Learned counsel for the appellant in MFA 1301 of 22 is permitted to file certified copy of the judgment after obtaining round seal within 3 weeks. ಯಾವ್ದ್ರಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರೇ ಇಲ್ಲ Padma yes, 2 weeks time granted at request of R2. Not related. Registry to delete. Huh?
ಆಗಿಲ್ಲ.
Yeah, the TCR received, not applicable. Let it lie. Is it disposed of or pending? Even if it is tagged on, it doesn't make much of a difference. That must be disposed of. Next. Who's your opponent? Geeta, Madam Geeta. All right, next week. List of council. Huh? ಇದು ಆಗಿದೆಯೇನೋ ಅದೇ ನಿಮ್ಮ ಇವ್ರು ಮಾಡಿದ್ರಲ್ಲ ದಿಸ್ ಇಸ್ ದಟ್ ಐ ಥಿಂಕ್ ಬೋತ್ ದ ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್ ಟೈಪ್ ಐ ಲಿಸ್ಟ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂಡ್ ಪಾಸ್ ದಿ ಆರ್ಡರ್ಸ್ ನಥಿಂಗ್ ಐ ಥಿಂಕ್ ಫರ್ದರ್ ಇಸ್ ದೇರ್ ರಿಲೀಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್
7th July, Swami.
ಅದಮ್ಮ
37 question.
37 ಮಂಡೇ ಮಾಡ್ತೀರಾ ಮಂಡೇ ಓಕೆ ರಿಲೀಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 26
38.
Notice to R2 is dispensed. Notice to R1 at risk of. We'll accept it. Notice to R2 dispensed at the risk of appellant. Memo accepted. The wakalat filed by Eleven Council Sharanappa Gowda Mali Patil for R1 is accepted. List on 29.
Yes. Assessment at the full body has been assessed for 16.
If claimant. First time.
First time.
Notice of vehicle. Issue notice to respond. Records, secure records.
40.
ನಿಮ್ಮ ಹೆಸರು ಲೋಹಿತ.
Serial first time. First time.
All right, madam. Huh?
After assessment I completed ಮಾಡಿದ್ದೀನಿ ಮತ್ತೆ income completed
ನೋಡು. Yes, secure records ಬರುತ್ತೆ ಅವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. What is the same? ಇದರಲ್ಲೂ ಸೇಮ್ ಅಲ್ಲ ಸೇಮ್. Yes, Mr. Ashok. Stay is required. What do you put? Hard learners council for the appellant. Issue notice with the respondents. Issue notice to respondent number 1. Notice to R2 is dispensed. The risk of appellant. Orders on IA1. There shall be stay of operation and execution of the judgment and award dated 18/11/23 in MVC 4297 asked by 20th additional small causes judge. ECM Bangalore SCC 22 subject to the appellant depositing 50% of the award amount within 4 weeks before this court.
Tejas and
Issue notice. ಇದೇ ಮಾಡ್ತೀರಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾಕೆ ಇವಾಗೆಲ್ಲ ಕೂತು ನೋಡಿದಿರಲ್ಲ ಎಷ್ಟೊಂದು ಜನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ ನೀವು ರೆಡಿ ಆಗಿ ಬನ್ನಿ ಪ್ರಾಕ್ಟೀಸ್ how many months you have practiced 3 months then you sit next to the senior see how he argues and next case you can argue yes madam Kavita you start ಮಾಡಿಲ್ಲ ಅಲ್ಲ ಇದರಲ್ಲಿ ಮಂಡೇ ಮಾಡ್ತೀರಾ request of both councils released on Monday 26th
25.
request Senate council or the appellant released after a week ಮಾಡ್ರಿ 2016 old matter
47.
Asiagar synopsis memo citation filed by respondents kept below. So Asiagar Krishnamurthy
7.
this matter next week.
So, 5, sir.
That case, you are ready to argue. Okay, we'll have it on Monday. And you can sit down. Sit down. Monday, Matira? Sit on Monday. It's on Monday, 26th.
5.
Some water.
Court of sir. Court of sir. Oh, next week, Okay, okay. Thank you.
Monday. Sorry, feel ಆಯ್ತು. ನನಗೇನು ಏನೋ ಸ್ವಲ್ಪ ಎಕ್ಸ್ಟ್ರಾರ್ಡಿನರಿ ಹೇಳ್ದಂಗಾಯ್ತು. ಅದನ್ನ ಹೇಳ್ಕೊಂಡೆ ಅಷ್ಟೇ, ಹಿಂಗ್ ಅನ್ಸ್ತು ನನಗೆ ಅಂತ ಒಳಗೆ ಕೇಳ್ಕೊಂಡೆ. ಹೇಳಿದ್ಲ ಅವಳು. ಆಯ್ತು ಹೋಗು. ಈಗ ಏನ್ ಗೊತ್ತಾ ನೋಡ್ಬೇಕು, ನಾವು ಮನಸ್ಸುಗಳನ್ನ ಕೆಡ್ಸ್ಕೊಳಂಗಿಲ್ಲ. ಯಾಕೆ ಮಾತಾಡೋದು ಯಾಕಂತ ಅನ್ಸ್ತು ಅಂತ ಯಾಕೋ ಹಿಂಗ್ ಮಾತಾಡೋದು
ಯಾರ ಹತ್ರನೂ
ಇಲ್ಲ. ಅಂದ್ರೆ ನಂಗೆ ಮೊನ್ನೆ ಫೀಲ್ ಆಯ್ತು, ಇವಾಗ ನನ್ಗೆ ನಂತರ ಫೀಲ್ ಆಗಿರ್ಲಿಲ್ಲ. ಮೊನ್ನೆ 2 ಸರಿ ಹೇಳಿದ್ನೆ, ರಿಪೀಟ್ ಮಾಡೋದಿಲ್ಲ. ಅದೇ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮೇಲೆ ಹಾಕಿ ಹಾಕ್ತಿವಲ್ಲ, ಯಾವ್ದು ಮಿಸ್ ಮಾಡಿದೀವಿ ಹೇಳಿ?
ಇಲ್ಲ ಯಾವಾಗ್ಲೂ ಮತ್ತೆ ನಾನು ಫೋನ್ ಮಾಡ್ಬೇಕಲ್ಲ ಅಂತ ಒಂದೇ ಸಲ ಕೇಳ್ಕೊಂಡ್ಬಿಟ್ಟೆ ಅಷ್ಟು ಬಿಟ್ರೆ ಇನ್ಯಾವ್ದು
ಸಾಮಾನ್ಯ ಯಾವ್ದು ನಾವು ಮಿಸ್ ಮಾಡಲ್ಲ.
ಮಾಡಿರಲ್ಲ, ನಾನ್ ಬರ್ಕೊಂಡು
ಫೀಲ್ ಆಯ್ತು ಮೊನ್ನೆ ಮಾತಾಡಿದ್ದು. ಅದಕ್ಕೆ ಆ ತರ ಹೇಳ್ಕೊಂಡೆ ಅಷ್ಟೇ. ಹೇಳ್ಕೊಂಡ್ರೆ ಒಂಥರ ಸಮಾಧಾನ ಅಂತ. ಸ್ವಲ್ಪ ಅವತ್ತು ಲ್ಯಾಟಿಟ್ಯೂಡ್ ಅಲ್ಲಿ ಮಾತಾಡುವಾಗ